gives me great pleasure to introduce our final panel of the day. It'll be covering privatization of warfare. Our moderator today is Professor Richard Painter. He's the S. Walter Ritchie Professor of Corporate Law. He works a lot on government ethics and he's worked in the White House. He's testified before Congress. He's written several books on ethics and government ethics in general. And please join me in welcoming him to our panel. Thank you.
Thank you very much. I hope we can have a productive and engaging discussion. I'm going to encourage panelists and members of the audience to direct their comments and questions at specific issues so we could treat this as a learning experience. And I know there are many different views on these topics, and I hope all those views can be shared in a way that is conducive to a discussion that we can all learn from and hopefully inform our public policymakers about. The panelists, we have a very distinguished group of panelists. And there's biographical information on each of them, I believe, in the materials that have been handed out, I hope. But just briefly, Professor Gabor Rona is an expert on human rights law and international law, human rights litigation. Professor Rona has been a member of the UN Working Group on the Use of Mercenaries and is a lecturer in law at the Columbia Law School and has done a lot of work with the Red Cross and other international organizations. Dr. Daphne Richemond-Barak is also a very well-respected expert on international law and human rights and has worked for the International Court of Justice and has been in private practice at the Clear Gottlieb firm, one of the most well-respected firms in New York, and has done a lot of work on international transactions and also human rights related work, and she is now a professor lecturer in law in Israel at a very distinguished university in Israel. And Professor Geoffrey Korn is a presidential research professor of law at South Texas College of Law in Houston. He also is an expert on the law of war and has worked extensively with the United States military on issues relevant to the law of war and has published extensively on armed conflict and national security law and criminal procedure and criminal ethics. So this is a very well-informed group, and I think will bring a variety of perspectives. And once again, I will encourage the audience to step in with their perspectives as well as the time is appropriate. So would we begin with, I guess, Professor Rona? Is that the order in which we...
Okay. Thank you very much, and I want to express my appreciation to the Journal for having invited me to participate here today. I'm speaking today from the perspective of the Mercenaries Working Group, which is one of the so-called special procedures of the United Nations Human Rights Council. There are a number of so-called special rapporteurs and working groups that work on thematic human rights issues or work specifically on country-based issues. Mine is the working group on mercenaries. Now, I also want to do a little definitional aside on this question of what is a mercenary. We're here to talk about the privatization of warfare, and that brings to mind the increasing use of private military and security contractors. So I think it's important at the outset to understand some of the distinctions between what is a mercenary and what is a private military or security contractor that may or may not be also associated with mercenarism. The employees of private military contracting companies generally do not meet the legal definition of mercenary that is set out in international treaty law. It's set out in the first additional protocol to the Geneva Conventions. And it's also set out in an international convention that speaks specifically to the prohibition of recruitment, use, financing, and training of mercenaries. And there's also an African convention on mercenaries as well. So let me just point to maybe three of the major distinctions between a mercenary and a non-mercenary that may be a private military contractor. For example, although a private military contracting employee may participate in hostilities in an armed conflict, the majority of them do not conduct combat operations, whereas part of the definition of being a mercenary is actually fighting in a war. Also, private military security contracting employees are often nationals of or residents of the state that is a party to an armed conflict. A mercenary, by definition, is someone who is not a national or not a resident of the state that is a party to the armed conflict. It has to be a foreigner. Private military security contracting employees sometimes operate in a military chain of command and are considered as members of the armed forces, whereas a mercenary operates outside of a military chain of command. So these are three of the most important distinctions between mercenaries and private military contractors. Now, there are some domestic legal prohibitions, and there are some international legal prohibitions as well against mercenarism, as I already mentioned a couple of them. But there is no international regulation specifically addressing private military and security contractors. Meanwhile, there's been a huge increase in the involvement, and I'll call them PMSCs from here on in, private military and security contractors, in conflict environments, particularly in the last generation. They perform any number of functions, from cooking your eggs to killing and detaining your enemies, real or perceived. The more they are injected into what traditionally have been considered inherent state functions, like fighting and detention operations, the greater the likelihood that they may operate in ways that implicate human rights. And the more they are injected into conflict situations, the greater the likelihood that the laws of armed conflict, primarily the Geneva Conventions, will apply to their behavior, but that actual accountability will be lacking. The difference between the application of human rights and the application of humanitarian law, the law of armed conflict, is important here. Private entities, like private military and security contractors, they may have legal obligations that affect human rights, but the prevailing view of international law is that human rights law does not bind private players, does not bind private actors. It's addressed to states, not private enterprise. Humanitarian law, the law of armed conflict, on the other hand, speaks to the rights and responsibilities of parties to armed conflict. Those parties may be states, they may be non-state entities, and they are also the individuals who find themselves wrapped up in armed conflict situations. So, humanitarian law will address the activities of private military and security contractors, usually as individuals, but human rights law does not. The blurring of the boundaries between the state and private enterprise is another consideration, and it's not a new one. The Dutch East India Company was more powerful than many states in its day, and it performed state or state-like functions, for better or worse. And today, a private military or security contractor, PMSC, it may be organized in State A, it may recruit its personnel from State B, and it may have its operations in State C. And so the question of a single state's regulatory framework, the existence of a single state's regulatory framework, may not be enough to provide for accountability, to provide for the victims of violations by PMSCs to find their day in court, to have their remedy. While some states have national legislation specifically addressed to PMSCs, most do not. And there is simply no international mechanism to address these critical issues, such as vetting, training, scope of permissible activities, and accountability for remedies and remedies for violations. Let me tell you a little bit about my working group. We conduct country visits. We receive individual communications, complaint about the activities of mercenaries and private military contractors. We promote and participate in various initiatives. For example, we comment on proposed national legislation involving PMSCs and on international control mechanisms. We collect and study national legislation. We organize and participate in events. And we report annually to the General Assembly and the Human Rights Council. Today, I want to just briefly close with 3 ongoing initiatives that address the problems of accountability of private military security contractors in which my working group has a stake and is involved. They are the Montreux document, the International Code of Conduct, and the Draft International Convention on PMSCs. So first, Montreux. The Montreux document is about a 5-year-old document that the Swiss government and the International Committee of the Red Cross, my former employer, cooperated to draft. And it does 2 things. It sets out the obligations of private military security contractors in situations of armed conflict only. In other words, their IHL obligations. Their obligations under humanitarian law. And second, it lays out a series of best practices for PMSCs in armed conflict situations. The important thing to remember about Montreux is it's not a treaty, it's not law, it's a statement of what the law is and best practices, but it's only applicable to, and it only addresses, private contractors operating in armed conflict situations. The purpose of the document was to create a foundation upon which states would legislate accountability of PMSCs. My working group, which is now studying the state of national legislation worldwide, is finding that there actually isn't that much follow-up to the Montreux desire to see states actually implement in their national legislations, laws that provide for accountability of private military contractors and remedies for victims. Meanwhile, there's another initiative that I'll move to now, the International Code of Conduct. This is a voluntary code that's been developed for the industry. It's a work in progress involving negotiations among industry, government, and civil society representatives. Important issues like how contractors will deal with allegations of human rights violations are as yet unsettled, and no matter how they are settled, it's important to recall that this is a voluntary industry initiative. It is extremely useful if it turns out well, but it still cannot and does not take the place of law and regulation. The third item that I want to talk about, initiative, is a draft convention, a draft international treaty for the regulation of private military contractors. My working group has proposed a draft of an international convention which would be binding law designated to fill the accountability gap, to provide for remedies to victims, and to prohibit contractors from actually fighting in wars. At present, as I mentioned, there is no international legal prohibition against involving accountability of contractors, and there's also no international legal prohibition against contractors directly participating in hostilities in an armed conflict. The laws of war do not prohibit that. So there's quite a bit that an international convention can do to fill gaps of accountabilities, remedies, and questions about the scope of permissible activities of private military contractors. An international convention could also require states to establish jurisdiction over companies from that state for their conduct occurring in other states, particularly when the other state is, say, a failed or a failing state, one involved in an armed conflict situation, where the contractors might be involved in human rights violations and may enjoy official immunity by virtue of an international agreement, to that effect, or may simply enjoy de facto impunity because of the lack of will or an inability of a local judicial system to see the needs of accountability and remedies. This convention is under consideration by an open-ended intergovernmental working group that meets annually under the authority of the Human Rights Council in Geneva. So with these three initiatives, the Montreux document, the International Code of Conduct, which is a work in progress, and the draft convention, which is merely a proposal, there is developing a frame that, in a complementary fashion, will meet the gaps that exist now in international regulation on questions of what are the permissible scope of activities of these contractors? How are they vetted based on their previous conduct? How do they vet their own employees to determine whether or not they're hiring the right people or wrong people? And perhaps most importantly, what mechanisms will exist so that there is no impunity gap, so that when private military and security contractors violate the laws of armed conflict, violate the human rights of individuals, they will be held to account. Their victims will be able to find a forum for a remedy. So all of these mechanisms are in fact complementary. They're propositions that each focus on a different aspect or a different context or maybe a different stakeholder to bring a complex and, I'm afraid, irreversible trend within the rule of law. Thank you.
Thank you very much, Professor Rona. Our next speaker is Dr. Richemond-Barak. I noticed that while she's been at the Interdisciplinary Center in Israel, she has worked on a book which is forthcoming with a very relevant title, Privatizing War, Legal, Moral, and Historical Reflections on the Status of Private Military Contractors. Mm-hmm. I assume that's forthcoming.
Yes, forthcoming, yes.
We very much look forward to it.
Thank you, thank you. Thank you all. I wanted to first of all thank the journal editors and staff and the law school for inviting me to come here and speak to you today. I want to thank Gordon and Allison and Chris and Betsy for picking me up and everyone else for being such graceful hosts here, and it's a pleasure to be in the cold Minnesota weather. And I think I wanted to I want to kind of replace our discussion here in the context of what we've seen since this and heard more accurately since this morning. And what we are talking about now is the outsourcing of private security and military functions to private actors, and traditionally functions that were traditionally those carried out by the military that are now carried out by private actors. But if you try to think about it in a big picture kind of way and think about the robots that we talked about this morning and cyber and about areas that are growing in importance and that the law is having difficulty regulating, this is exactly the situation in which we were about 10 years ago. If I had been speaking before you in 2003 about the private security and military industry, I would have raised about 100,000 questions and told you, well, listen, we are going to try to figure those out, and let's meet in 10 years and see what the law looks like. And of course, today, instead of 100,000 questions, we only have about 50,000 questions, right? So we still have a lot of questions out there. But what's important to understand is that if you fast forward the discourse on cyber and robots 10 years from now, we are likely to be speaking about a very similar issues that we are speaking today about the private security and military industry. In other words, much progress has been made in the regulation of the outsourcing of private war and security. And the question that we need to ask today is, are we better off today that we've actually tried to regulate this area of the law and try to adapt the law to this, to the growing involvement of these actors on the battlefield and also remotely, carrying out increasingly wide array of functions and increasingly sensitive array of functions. So, so it's important to understand that if you fast forward the process on cyber and robotics, you're likely to see something very similar that what we have today. The process is likely to be very similar to what has been going on in the private security and military industry. So there is something to learn in other words, from this regulatory process that we talk about today for other fields like cyber or like robotics. And when I asked my question this morning, that's what I was hinting at when I asked, what do you think the regulation will look like in robotics and in cyber? And the reason why I asked this is because I think the regulation will very much look like what we have today in the realm of the private security and military outsourcing. It will be a kind of a soft regulation, codes of conduct, guidelines, very fragmented, different initiatives, and I'm going to get at that now. But before I got into the details, I wanted to kind of reset the frame for that. So in the private security and military industry, in other words, for the past decade, we have seen many developments, many different attempts at enhancing the legal framework applicable to these relatively new actors, in the sense that they are historically connected to mercenaries, but very different. And I'm not going to get into why they're different, but Professor Rona touched upon this. They're very different, and so many regulatory developments taking place in the last decade trying to enhance this, the legal framework applicable to their activities. And just so that you understand how quickly this is moving, the most recent development dates from just a few days ago with the publication of a new proposal to enhance the oversight and the monitoring of the private security and military sector, which I'll go back on later. But so what we have today is a very disorganized and fragmented framework, which is made up very largely of the initiatives that Professor Rona talked about, but also of other things that I'm going to discuss. But what we have is this disorganized and fragmented framework developing alongside the core corpus of international humanitarian law in two parallel tracks, if you wish, with many connections and overlaps, of course, but still a different track, because we're talking about a soft, more multi-stakeholder, more inclusive process. But that other track, that self-regulatory track that we are talking about, is affecting and is changing the fabric of IHL, of humanitarian law, and is creating the law of tomorrow's battlefield, whether we like it or not. And in fact, both the Montreux document and the International Code of Conduct, they say, very clearly, we, the instruments, do not mean to create new law. Well, guess what? You may not mean to create new law, but you are creating new law, or at least you are very significantly affecting the fabric of the law that we have today, which is international humanitarian law. So I want to address briefly two questions. The first question is, what does this law look like, the law of tomorrow's battlefield in the realm of private war and security? What does it look like, this new law? And second of all, and perhaps most importantly, is this good law? At plus 10, should be satisfied with the normative outcome that we have achieved by way of these new new regulatory framework. So again, what does the law look like to begin with? And here I'm going to kind of expand on what Professor Rona just exposed to you. The most important thing to know about this new law, whether or not we accept that it's law, but I'll call it law in quote unquote, is that it challenges the traditional divide between public and private. And in that sense, it's also very different from traditional IHL. And it consists of self-regulation, industry regulation, and multi-stakeholder initiatives. So if you think about it, there are three different levels of self-regulation within the industry today, one of which is the multi-stakeholder initiatives that Professor Rona talked about. So the multi-stakeholder initiatives, which are state-led by Switzerland and in cooperation with the ICRC, and include and kind of try to find, to accept standards that are adopted by the industry itself, by the private sector, by the companies, by states, and by civil society. So that's the multi-stakeholder level. But in addition to this level, and now you understand how fragmented we're really talking about here, we have industry associations, which are themselves adopting codes of conduct and developing and promoting self-regulation in the industry. And so that's another level of self-regulation in addition to multi-stakeholder initiatives. And finally, we have the company level of self-regulation. Companies themselves have internalized and kind of incorporated the principles developed in the Montreux document and the International Code of Conduct into their own internal regulation. So really, we're talking about company codes of conduct within a company, and the companies have also increasingly established mechanisms, internal mechanisms within the companies designed to kind of monitor the compliance of employees and of the company itself with the industry standards. So 3 levels: multi-stakeholder initiatives, industry associations, and company codes of conduct. So this is the fragmented framework. On top of that, you have the UN initiatives of the Draft Convention, and you have within the United States actually yet an additional initiative, which I don't want to get into, but I'm just mentioning it so that you understand that there's really a proliferation of mechanisms which are self-regulatory and voluntary in nature. So what are the main characteristics of this new law that is emerging to govern the outsourcing of of security and military functions? It is informal, it is non-binding, it is voluntary, it is seen as a complement to the law and not as a replacement to the law. Like I said, it's very fragmented. It is evolving very rapidly, and it is increasingly sophisticated. And it's constantly on the move. Like I said, just a few days ago, there was another proposal coming on the table. And so this is really the kind of emerging regulatory framework that we have governing the outsourcing of security and military services. So the question is, are we better off today than we were a decade ago? Should we be satisfied with the normative outcome produced by these instruments, by this self-regulatory framework? And I think in order to have a credible criticism of this framework, we need to acknowledge what it has actually achieved. What does it have achieved? What has it achieved in the past decade? First of all, there has been an elaboration of standards. So in terms of standard setting, there has been some progress. And definitely these frameworks, these self-regulatory frameworks have gone further than other more traditional forms of governance, like treaties, for example, or even national legislation. So in terms of standard setting, we've gone a long way. We have now industry standards that are accepted by all industry players. We've made very major advances also in terms of participation. All industry players, like I said, participate in the elaboration of this regulation, which is quite novel. The membership in industry association has very much grown in recent years. We have hundreds of companies that have signed on to the International Code of Conduct. The schemes, the regulatory schemes in and of themselves are very participatory and involve all industry players. But, of course, the idea is not to paint a rosy picture of the situation. There have been advances in participation, but we still need to know exactly how each stakeholder is influencing this regulation. So how are states influencing the regulation? How is the private sector influencing this regulation? For example, the fact that companies are involved in making the regulation, do they actually advocate a lowering of the standards or not? So we need to know more in order to have a good judgment or good assessment of what we have achieved, but the processes have become increasingly participatory. We have consultations, even within the UN, consultation between all the stakeholders. But again, some progress to be made nevertheless. Another benchmark that we can look at when we're trying to assess the progress made by this regulation is in terms of transparency. And the truth is, it used to be very difficult to find information about this industry. There used to be very little information in the public domain 10 years ago, if I had spoken to you in 2003. But today, most companies are pretty straightforward about who are their clients, what kind of services they provide, about their policies. You can find information on their websites. Some of them even post sample contracts. Industry associations are very open in how they conduct, for example, revisions of the codes of conduct that they have. And even within the United Nations, we see more openness talking about the use of private security and military companies. And there's public debate about this issue, which in and of itself demonstrates a level of transparency. So We have more transparency than we used to, and so the regulatory framework has indeed advanced that aspect. What remains to be done in the realm of transparency? We need to know more about instances of violation. When are companies actually witnessing instances of violations? We should know about those. There should be data collected about instances of violation. And we should know also more about how their internal mechanisms for monitoring compliance with the standards actually work. I was in San Remo in September in a conference on private security and military contractors, and I spoke to one of the legal counsels of one of these companies, and I asked her, so can you tell me more about your internal complaint mechanism? And then as she was telling me more about it, I realized this internal complaint mechanism is not at all used for what I thought it would be used for, which is compliance with these standards. But she explained to me that this is employees use it to complain about administrative issues, payment issues, and so I felt like there's a gap between what we think those internal mechanisms are used for and what they're actually used for. So that's something that I think we need to know more about. So that's for transparency and participation. Now, in terms of accountability, which I'll use as my third benchmark for trying to assess the impact of this regulatory framework, we need more both soft accountability and hard accountability. We're in the realm of global governance here, so of course it's hard to know what exactly accountability means in the context of global governance. But we need more naming and shaming. We need more public decisions, like I said, data, information about violations and about how companies behave. But I guess my point is, I think when we look at the discourse and the criticism that has been made of this regulatory framework, I think in a way it is misplaced. And I want to try to explain that very briefly. What we hear is that the industry should not self-regulate. It should not, because it should be instead regulated by the classic traditional IHL framework, or more traditional forms of governance, or maybe a UN treaty. So that's one of the criticisms that we hear. It's because it's informal and voluntary, that's not appropriate. Another criticism that we hear is that the industry is simply not capable of self-regulating. And I think I disagree with both of these criticisms. And I think the criticism is misplaced. Where should we actually focus our criticism, in my view? In two things. The limitations of this self-regulatory framework, in two ways. If you look at all the proposals that are on the table and all of these frameworks that are emerging, none of them contemplate an actual sanctioning mechanism for non-compliant actors. What does it mean? If a company violates the industry standards, that company will be either suspended or expelled from the scheme in question. So either expelled from the industry association or expelled from this initiative undertaken by the Swiss and the ICRC. And in some cases, the company can be actually expelled and then reapply a few years later. And that's the same for all schemes that exist at the moment. There is nothing beyond expulsion or suspension from the schemes. And I think that's insufficient. So I think that's actually one aspect on which we should focus. The other aspect on which we should focus, in my view, is to make sure that we have a double layer of accountability. Most of the schemes that we have that have emerged today focus on corporations and corporate accountability. And I think we need to create incentives for the individual contractor who is deployed in the theater of operations to actually comply with the industry standards. So if you wish, you have the hiring entity, then you have the corporation, and then you have the employee. We need to make sure that it's not even a double layer of accountability. We should have a triple layer of accountability. The hiring entity, which is often the state, and then the corporation, but also, and let's not forget, the individual. And I think that's one of the limitations of the current framework, that it doesn't sufficiently take into account the individual and doesn't give the individual sufficient incentive for complying with the schemes. So I have my thoughts about how we can achieve that, how we can make sure that there's actual sanctioning, and how we can make sure that all of these layers of accountabilities are actually contemplated. But I'll leave it at that for now, and I can expand for it if you want more in a discussion. But I think if we actually focus our criticism on these 2 points, and on perhaps also some of the further progress we can make in participation and in transparency, then we have a credible criticism. And like Professor Gross said this morning about robots, the train has already left the station, okay? So we're not going to ban now outsourcing. We're not going to revert to a completely government. All these functions are not going to go back and be carried out by the government or by the army. Outsourcing is here to stay, at least for the moment. So we need to contemplate a regulation that works, and I think self-regulation is actually a promising route if we only keep in mind those very important points that I've raised, that we need proper sanctioning and that we need to focus on both corporations and individuals. Thank you.
Thank you very much. And our next speaker is Professor Geoffrey Korn.
Thank you. Well, you know, I think first off I'd like to echo the thanks that both my friends Gabor and Daphne made to the law school, to the journal, and to everybody who helped put this together. I basically just cite Daphne, except for the comment on the cold weather. It was 64 degrees at 6 o'clock this morning when I left Houston, and a little bit hard to get used to hitting the outside of the airport here.
I come from Tel Aviv.
Understand?
Okay.
I know where you come from. I want to maybe offer a little bit different perspective than Daphne. Daphne closed her remarks by saying privatization is here to stay. And I do agree that privatization of warfare in many ways is like the technological innovation of warfare. If you create a market for the private sector will seek to fill it. And I think in large measure the all-volunteer force and the trend in Western democracies to move away from a expectation of national service to an all-volunteer force, restricted budgets, is inevitably going to push force development managers to look to the private sector to fill gaps. But the change in the way the private sector has played a role in the planning and execution of military operations in the last 20 or 30 years is truly radical. I joined the Army in 1983, and we had civilians that supported the Army back then, and they kind of handed out your uniform at the depot when you got there and maybe gave you your haircut, but that was about it. When you went out to the field to train, you didn't see a lot of civilians. At one point in Iraq, the United States had over 100,000 civilian contractors supporting military operations. Now, I want to make something clear at the outset. I don't think there's any problem with using civilians for an appropriate function. But I think there is a problem when civilians are being permitted to increasingly engage in functions that should be reserved to members of the armed forces for good historical reasons. My thesis is that only members of the armed forces should be able to engage in functions that involve an exercise of discretion that implicates compliance with the law of armed conflict or international humanitarian law. That it's improper to vest that discretion in the hands of private contractors or private organizations for a number of reasons. I've been doing a lot of thought about an article that I want to work on, generally titled "The Moral Relevance of Legal Fictions in the Law of Armed Conflict." And I think there are quite a few legal fictions in the law of armed conflict. And they're easily exposed if you really think about them. But what I keep going back to is that those legal fictions are built on a moral foundation, and they play a critical moral role. And I think when we talk about the privatization of war or armed conflict, or as Daphne used the term, private military, which for me seems like an oxymoron, it really starts to expose some of these legal fictions. Two that I want to focus on specifically are whether we like it or not, the legal fiction that necessity can never override the prohibition against inflicting harm on a person who is hors de combat, at your mercy, like coercion. Now let me make it clear, I'm not suggesting that these fictions are invalid. I just think that you can come up with a hypothetical where you can challenge that rule and expose the fact that there is an element of legal fiction to it. I think it's morally vital. And the other is that only armed forces should be able to participate in hostilities. I think both of these are founded on a solid moral ground, and I think they're morally vital for the protection not only of the interests of the state, but also of the victims of war and also of the individuals who we call upon to participate in hostilities. So my focus is how privatization will continue to stress these fictions to expose them, but why it's important to step back and ask whether or not states should be more cautious about resisting this inevitable trend that Daphne points out. Because I do agree with Daphne that if you create a market, the private sector will seek to fill it. Let's start with the issue of necessity and coercion. Coercion of detainees, coercive interrogation techniques, torture, whatever you want to characterize it, has been obviously a lightning bolt issue for the United States since 2001 and the initiation of hostilities against what we consider to be an organized, armed, belligerent group justifying invocation of the law of armed conflict. Now, the military legal experts that were involved in the assessment of proposed enhanced interrogation techniques consistently resisted the desire to authorize these techniques. And it was quite frequently the views of civilian legal experts and policy experts that prevailed in this debate to authorize some of these measures. There were also apparently episodes of private contractors being used as interrogators that would encourage the military personnel in detention facilities to basically set the conditions with detainees before they conducted the interrogation by subjecting them to cruel, inhuman, or degrading treatment. Now, why do I think privatization increases the risk of diluting the understanding of the importance of the respect for the fundamental principle of international humanitarian law, that there are certain things that can never be justified by military necessity? Now, by the way, I have to take issue to those of you in the audience who said that the law of armed conflict or international humanitarian law doesn't have a protective element to it. There is an entire prong of international humanitarian law called the Geneva Tradition, which is focused almost exclusively on protecting victims of war. And one of the most important developments in the law of armed conflict has been the recognition by states that military necessity is not an unlimited justification. There are certain things that can never be necessary. And one of the most important things that can never be justified by necessity is the cruel, inhuman, or degrading treatment of somebody who's at your mercy, whether it's a captured prisoner, an unprivileged belligerent, a civilian internee, somebody who's wounded and in your medical facility, whatever the case may be. This is an axiom of the law of war. But I think it's one that when you boil it down to the immediate decision-making process of a young soldier can sometimes be hard to understand. And so that soldier has to be subjected to responsible command, has to be in a culture that cultivates understanding and compliance with these norms, and has to be taught that his decision or her decision to make an immediate judgment of their own individual necessity can compromise the ultimate objective of the nation, of the organization, of the mission itself. This is the logic behind the law. There's also a moral element to this. Military leaders who were at the core of developing what we talk about when we talk about core principles of international humanitarian law, they were central to this development, understood that if you didn't put limits on war, you would corrode the moral foundation of the people the state was asking to fight the war for them. That's what leadership is about. Leadership is helping subordinates understand the fine line between necessary brutality and humanity in the most inhumane context. I want to read to you something from a book that was written in 1970 by an author named James McDonough that really points this out. The name of the book is called Platoon Leader, and it's a seminal work. It's a memoir of an American officer, a young officer, infantry officer in Vietnam in 1970, tasked with the responsibility of leading troops in what at that time was considered the most asymmetric war we had ever fought. So when we talk about asymmetric warfare and emerging technology and enemies that don't follow the rules, this is not something that's new. This is what he said in his memoir. This was not a lawyer. I had to do more than keep them alive. I had to preserve their human dignity. I was making them kill, forcing them to commit the most uncivilized of acts. But at the same time, I had to keep them civilized. That was my duty as their leader. War gives the appearance of condoning almost everything, but men must live with their actions for a long time afterward. A leader has to help them understand that there are lines that they must not cross. He is their link to normalcy, to order, to humanity. If the leader loses his own sense of propriety or shrinks from his duty, anything will be allowed. War is, at its very core, the absence of order, and the absence of order leads very easily to the absence of morality, unless the leader can preserve each of them in its place. Now, why do I read that? I don't want to suggest that somebody who's responsible for running a contract for a private military organization that's responsible for conducting interrogation is incapable of embracing that ethos. But I don't believe they come from the same culture that breeds that ethos in leaders. My son is a cadet at the United States Air Force Academy, and I marvel at the moral and ethical foundation that is being inculcated in those future leaders, those young men and women who've made the decision to be leaders in the most difficult situations our nation will call on them to confront. And I don't think that a private corporation shares that same value set necessarily. What frightens me also is that when we talk about private, we talk about profit. Profit is an ultimate motive, getting the next contract, producing the outcome that's desired. And I think that can very easily dilute the moral foundation that is the basis for these limitations that impose restraint on the warrior who's operating in a very different culture. So I am concerned that allowing private military contractors to deal with individuals who are at the mercy of the state instead of military personnel is a recipe to increase the probability of abuse and misconduct. And for me, the concern is not just the post hoc sanction, the regulation, the investigation, the prosecution. The more important concern is whether the state is justified in resorting to this tool to achieve its objective, and why the state is resorting to that tool. So that's the first fiction I want to talk about, or the first challenge I want to talk about. The second is the assumption that only members of the armed forces should be permitted to engage in hostilities. Again, this is a bedrock principle of international humanitarian law. If you go back to the 1880 Oxford Manual on the Law of War, the 1899 Hague Convention, the 1907 Hague Convention, it defines who a privileged belligerent is. These treaties say only members of the armed forces or militias properly associated with the armed forces operating under responsible command have the privilege of participating in hostilities. Of course, that begs the question what hostilities is. And this is an area that can be easily manipulated, managed, distorted, interpreted, whatever term you want to use, so that you can maximize the use of private entities to perform functions that historically were considered functions that belong to the armed forces. In my view, this is where that discretion issue comes in. The reason that armed forces are entitled to engage in hostilities, I believe, is because of the assumption that armed forces operate under responsible command. Commanders who are themselves responsible and accountable, both professionally and criminally, for the violations of the law of armed conflict committed by their subordinates under the doctrine of command responsibility. This is nothing radical. It's at the core of the humanitarian law compliance equation in the law of armed conflict. I'll read to you from the commentary to Additional Protocol 1, Article 85, which refers to command responsibility. In fact, the role of the commander is decisive, whether they are concerned with theater of military operations, occupied territories, or places of internment. The necessary measures for the proper application of the conventions and the protocol must be taken at the level of the troops, so that a fatal gap between the undertakings entered by the parties to the conflict and the conduct of individuals is avoided. The assumption is that if you are going to engage in activities in warfare that implicate compliance with the law of armed conflict, is that you are operating under responsible command. Now, a private military contractor may be associated with a military command, but in my view, they are not part of the military organization. They are a peripheral entity that is connected to the military organization. They don't grow up in the same culture. They're not inculcated with the same ethos. They don't view the relationship to the commander the same way as members of the military unit view that relationship. There's not the same level of fidelity between the command and the subordinate. There's not the same level of obedience between the subordinate and the command. And I think there's a dangerous inequity involved if we allow private military contractors to engage in conduct that would traditionally fall within the scope of armed forces. And that is that the commander, the military commander, may very well find herself criminally responsible for the war crimes committed by the private military contractors, but as we're learning from both Gabor and Daphne, that commander might not even have the disciplinary authority over those private military contractors to sanction them for their misconduct before they get to that point. To me, that's utterly inequitable. To me, the logic of command responsibility is you've got all the tools to ensure compliance by your subordinates, and therefore it's fair to make you accountable when you lose control of that organization. So only members subject to that traditional command authority, only individuals subject to that authority, should be permitted to engage in functions that implicate compliance with international humanitarian law. Now, I recognize that at some point this is going to become increasingly a fiction. If you talk about cyber operations, the question is, why is it so problematic to have a civilian develop the program that will conduct the cyber attack or have a civilian launch the virus? Well, just like the rule that says there are certain things that necessity never justifies, these are rules of presumption. They're rules that are based on presumption. And every presumption is overbroad and under-inclusive at the fringe. So there is certainly, you can certainly come up with hypotheticals where you can say, it doesn't really make a difference whether or not you allow a civilian to operate this drone or whether you allow a soldier to operate the drone. But I think it does make a difference because it preserves certain bright lines. And it keeps the military in the business of executing the obligation of engaging in hostilities, because it is the military that is brought up in that culture that James McDonough talked about. So before we go down that road, before we assume that this is an inevitable necessity, I think it's necessary to step back and say, what are the proper functions of private actors in armed hostilities? And I know that that's one of the points that Gabor brought up, is that there's no consensus on what that proper function is. I can tell you that our Department of Defense really struggles to try and draw certain logical and rational lines. Contrary to popular myth, most private military contractors are not private warriors, as Gabor noted. The vast majority of them are doing what are basically logistical tasks. And I don't think that's a problem. I think it's logical for a commander to try and increase what military personnel call the tooth-to-tail ratio. Maximize the number of people in uniform as the teeth of the organization by maximizing the number of civilians as the logistics tail of the organization. I think that's fine because when you're flipping pancakes or fixing a truck or repairing a tank, if you abuse your discretion, it's not going to result in a war crime. But when you're providing medical care to enemy personnel, when you're conducting interrogations, when you're using kinetic military force, your abuse of discretion can result in a war crime. And in my view, the only people that should be entrusted with that discretion are people who are subject to responsible command, and that means members of the state armed forces. Thank you.
Very much. I will thank all of the panel for very insightful comments. I'm going to just throw out quickly some questions and then have the audience jump in. And I'm a corporate securities lawyer, and most of my time with students is talking about the profit motive and how to constrain it in normal circumstances, not while conducting war, which of course involves ethical issues in itself. I also do a lot of work in government ethics, and I wrote a government ethics book where I had a whole chapter on the outsourcing of government functions, and I called it outsourcing of government function without outsourcing government ethics. And I discussed a lot of the conflict of interest rules that apply to government employees in the United States, financial conflict of interest rules and so forth, a lot of them criminal statutes that don't apply to contractors, and the terrible messes we'd gotten into in various parts of the government because we used contractors for government functions. And the impracticality of trying to discipline private contractors that came up again and again. Particularly in the warfare context, I see with the Blackwater incident and others, that it was extremely difficult to keep some of these people under control. You can't court-martial, or at least at the time there are certain provisions now you can use to try to do the equivalent, but you don't have the ability to court-martial. Your investigation, the ability to conduct an investigation is constrained. In terms of public transparency, forget it if the information is classified about what's going on in interrogations. You don't have that. And then when it comes to sanction time, you say, well, we'll revoke the contract. So we're going to revoke the contract, and you don't get to protect our ambassadors overseas. Well, if we've been depending on the contract, is nobody going to protect the ambassadors? I mean, we get into a situation where we're dependent on the military contractors, and it's, for me, been a very worrisome situation from the government ethics perspective. The other concern I've got is the impact on our political system, at least in the United States. There was this reference to the military-industrial complex. That wasn't some long hair in the 60s talking that way. It was President Dwight Eisenhower, who was the most famous general who's ever been president. I guess Ulysses S. Grant, but he was a somewhat less successful president. General Eisenhower, President Eisenhower, warned against the influence of the military-industrial complex on our political system and the political clout of military contractors simply who were manufacturing the equipment. Isn't that problem going to be that much worse if you had a private company conduct not only manufacturing the drone equipment, but, for example, deciding whether and how we're going to use it and implementing it? Wouldn't there be an enormous amount of lobbying by these private companies, campaign contributions and the rest of it, that would be directing our military policies at the highest levels, because Congress is going to have a lot of influence on those decisions. So doesn't this add to the corruption of our political system, the outsourcing of warfare?
Well, I think there's even another political element, which is I personally believe it makes it easier to use it. If the tool is a private contract, in my view, money is easier to justify expending than lives of American service members. And so if you think about the notion of kind of the inhibitors to the nation deciding to use military force traditionally, most of them have been generally eroded. Congress is not much of a force in that. As you note, this might make that even less of a force. The fiscal issues don't seem to be too troubling when we decide we need to use military force. We don't draft people anymore, so there's no political disincentive there. And I think through the 90s, the 80s and 90s, there was a perception in the military and politically that the American people were casualty averse. And I think even that has been diluted somewhat, but even less so when you're talking about contractors. How many people, most people have heard how many American servicemen have died in combat since 9/11. How many contractors have died? Nobody knows that number. That's one of those transparency points you bring up. So if you have this capability and it's increasingly robust and it's increasingly kind of sub rosa politically, will it increase the probability of using it? Now, we could get into debate whether that's a good or bad thing, but I think it is a reality that it's going to make it more likely.
I'm really pessimistic. I don't think there's any disagreement, at least as far as I know, on this panel about the dangers, the very deep dangers of privatization of warfare. But look how the U.S. political system operates. We have had perhaps a parallel experience with the privatization of prisons, and yet the forces at play in the privatization game there are extremely powerful and inevitable. And how many senators or congressmen are going to stand up and publicly say that they're willing to make do with fewer prison cells, or they're willing to make do with shorter prison terms if that saves money, in order to prevent having to privatize? That's on the assumption that privatization is a money saver, which is perhaps another myth that's that we tend to live by. And we tend to live by these myths in the privatization of prisons, and we're living by these myths in the privatization of the military, because of this extremely powerful combination, 1-2 punch, if you will, between the economic incentives and the ties that exist between those economic influences and people who run our politics and our government. So coming back to my idea of, I guess, gross pessimism here, I'd have to say, yeah, I think we all agree that there are huge dangers and huge negatives in privatization, but it's going to happen, and it has been happening, and is going to continue to happen, no matter how much we may agree that it's a bad thing. So while it's very important that there be parts of the body politic that say stand out in front of the offices of Raytheon, or stand out in front of the offices of McDonnell Douglas, or stand out in front of the offices of Kellogg Brown and Root and other military providers and contractors to protest what they do, and stand out in front of the halls of Congress as well. It's also important that there are others of us who, instead of doing the protesting against the thing itself, are involved in what may seem to be the contradictory process of narrowing it, regulating it, and making it work, whether we like the fact that it exists or not, in ways that do the least possible harm. And I think that's where the most bang for the buck is going to be in the foreseeable future. The things that we've been talking about concerning certain functions that private contractors should not be allowed to do, as Jeff mentioned. And as Daphne was talking about, the initiatives that have to keep gaining steam on prevention, and the things that I've been talking about accountability. Even if everything happens the way all of us sitting here want it to happen, it would still not be a good result. It would just be a better one than we have today.
I want to try to answer a little bit of what Jeff brought up in terms of. I think what you're trying to do, Jeff, is you're saying it's okay to privatize certain functions, but there are others that should not be privatized. And there's a real difficulty in this approach, because for the past, I would say again, for the past 10 years, some people have really tried to identify which functions can be privatized and which ones cannot. And this was one of the ways in which this has been done is, for example, by trying to identify or define what is a security function versus what is a military function. Or some people have adopted a different distinction and said, okay, you can use contractors for defensive purposes, but not for offensive purposes. And the truth is that all of these attempts are drawing distinctions between the various activities or functions performed by these actors have not been very promising. And I'll give you an example. Take Abu Ghraib 2004. You mentioned interrogation, but as you know, there were also contractors that were involved in they were working at Abu Ghraib as translators. So now, assuming I hadn't said that, right, or none of us knew about this, and I would ask you, so do you think that translation during an interrogation is a task that could lawfully or rightly so, legitimately be outsourced. And you'd say, you know what, it's not the interrogator himself or herself, it's a translator. You know, maybe yes. Well, and then it turns out that in a battlefield context or in that prison, the translators who were contractors were among the ones that performed violations of IHL. So now, that's one example, which is a seemingly not problematic task, and yet in practice it was problematic. And you talked about logistical tasks. So what are these logistical tasks that, according to where you're going, would be could be lawfully outsourced? And I don't know what is a logistical task in this context. You mentioned, I think, truck drivers. Let's think about the truck driver. So, and it's very similar to the discussion that we can have in a direct participation in hostility debate, actually. A truck driver, driving, I don't know, food, is that okay, bringing food to the soldier? Is that okay to outsource the truck driving of the food to the soldiers to a private entity? Would it be okay to outsource the driving of the ammunition to the armed forces to a private entity? In other words, I don't know how you can, and it's not just me, it's just all the work that has been done in the past few years in attempting to draw these distinctions has not gone anywhere, really.
Can I answer?
Yeah, just one more example. Manufacturing of weapons. And this is what you mentioned as well. Manufacturing of weapons. And I would add to that, maintenance of weaponry. So are these tasks, so operation of weaponry, okay, we'd agree, cannot be outsourced. But what about manufacturing those weapons or maintaining those weapons? Is that something that we could outsource? So I have a real problem, and again, it's not just me, it's just having seen where these attempts have led, I'm not convinced that this is the way to go. Well, I'll let you answer for now.
So I disagree with you. I think it's far more dangerous to concede that it's impossible to draw lines, because what you're essentially doing is you're going down a slippery slope. If it's too hard to figure out whether the translator or the interrogator or the truck driver or the weapon operator is a permissible civilian function, then eventually the question is going to be, well, why can't the guy who's driving the M1 tank be a civilian? Because the private marketplace can provide that for me just as well trained. And here's the thing about the Pentagon, folks. When they look at costs, they don't look at immediate costs, they look at out costs. When you bring a soldier in, you just don't bring the soldier. You bring health care, you bring potential VA benefits, you bring family benefits, housing for the family members, et cetera, et cetera. So the whole privatization motive is that it may cost more in the short term, but there's always going to be long-term gain if you can cut the end strength of the regular force. In every one of your examples, I think it goes back to the same basic question. Anybody, as Gabor says, anybody in the battle space, in an armed conflict, can potentially commit a crime. A civilian can commit a crime. A doctor can commit a crime. A nurse can commit a crime. They could do something that is just an aberration and violate law and harm somebody. But the question I would ask is, does the task you are assigning them involve the exercise of discretion that implicates compliance with international humanitarian law? So it's not, I don't agree that it's analogous to DPH, to direct participation in hostilities. Driving a truck, if you abuse your discretion driving a truck, you don't commit a war crime. If you abuse your discretion translating, you put an and instead of a but. But if you abuse your discretion interrogating, you physically harm somebody. And that's a war crime. So I think it is possible to draw a line by focusing on the function. And by the way, I think this is the practice that the United States has tried to engage in with the inherent governmental function standard. They look at the discretion associated with the function.
What if you can't draw a line in a particular instance, but you say, look, there are a large number of them you can draw the line. You could say, look, if it's the pancakes, making the pancakes, that will be something you can outsource. If it's driving the tank, you can't, at least in a combat zone. You'll have some in the middle. And we'll just say in the middle there's a very strong presumption against privatization. And the presumption could be overcome under certain circumstances where it's absolutely necessary or something like that, but just a very strong presumption against it in the middle. That's the way we often deal with line drawing in the law. Why not do that here?
No reason not to do that here. This would not be the first realm in which we create where we draw legal lines, although we don't know the precise place that the line drawing will take us in every single circumstance. It is in the nature of international humanitarian law that the closer the closer you look, the greater degree of magnification that you use for just about any rules application, you'll end up with a place where you just have to shrug your shoulders about whether particular conduct ends up on one side of a line or the other. So I think this is just one of the fictions that we live with under concepts of rule of law, and particularly in international law, and particularly in international humanitarian law. But the question shouldn't be, are there going to be instances in which we have to shrug our shoulders in the application of the rule that we thought was going to solve everything? The question, I think, would be, are we better off with an imprecise rule and a line than we are with no line at all?
So I want to open this up for questions from the audience. Sir.
Mr. Korn said that there was a necessity to look back.
To what?
Look back. Look back.
Uh-huh.
You know, I sort of feel that there is a necessity to look back at the very beginning. That is 9/11/7. And when that was a private military contractor involved in the destruction of the buildings at 9/11. The official report put out by the Bush and all did not mention anything about the third building that came down, building number 7.
Well, with all due respect to your question, and I don't want to I don't want to minimize your concern, but I think that the question of responsibility for 9/11 is fundamentally different than the focus of the three panelists.
I disagree with you.
Well, then we will respectfully disagree. I think there might be other questions more
whole thing.
focused.
You cannot talk about 9/11 in this university or any other university in the United States. And right here is the same thing.
I think you could if you had a panel. I think you could if you had a panel focused on that question. That's not what we were focused on. Thank you.
This was.
Yeah, another question, ma'am.
The business of line drawing, and of course we've had panels all day, and a lot of them were to the point saying that the train has left the station. It's impossible to go back and now, institute some firm principled lines. And we've kind of heard that all day. So I applaud at least this line drawing that you're attempting to do with the private contractors. I just wanted to mention that regarding the drones, there's a drone caucus. This ties in with the political corruption. There is already a drone caucus formed of 40 congresspersons, and it's already amounted to several $billions in campaign contributions. So when people say, oh, the train has left the station, there's nothing we can do about it, this political corruption and what Dwight Eisenhower warned about is, of course, what many of us are witnessing. So I encourage the more line drawing law, rule of law that we can have.
Let me offer just one thing in response to that. I don't think you should underestimate, right, the legitimate concern of senior leaders in uniform to a capability like drones being perceived as out of control. They have an interest in managing that capability because they recognize it has great potential to produce important and decisive effects in combat. So, there are a number of pressures involved in this issue, and I can tell you from my own, the people I'm connected to, that I think there's an evolution going on. Let me just say that. I think we saw it after when we talk about what happened at Guantanamo and the way things evolved, there was maybe you push too far, and then there's pushback from different sectors. Things start to regulate a little more. I'm not suggesting that everybody in here would agree that what's happening now is good or bad, but I think most people would agree that where we are now is at least better than where we were the first year after the operation began. I think there are a lot of influences beside just those influences that are going to impact the way this capability evolves and is managed and under whose authority it's utilized.
Sorry, I want to answer this because there was a misstatement of what I just said, so I just want to clarify. When I said the train has left the station, I meant we have been witnessing privatization for a good decade, 2 decades now, and I absolutely did not say that it's impossible to draw lines or have regulation of this phenomenon. Actually, that's absolutely the opposite of what I said. I said that I commend self-regulation, that I think it's a promising avenue, and in fact, I think that is the way that other areas of international humanitarian law will end up being regulated. And so we need to think about how it can best be exploited, enhance the potential of this mode of governance, and try to address its weaknesses. So absolutely not what I said. I encourage regulation. I think we have moved past the debate over whether privatization should be banned or over whether private security and military contractors are mercenaries. We are way beyond that debate, and now we need to focus on making sure that the environment in which those actors operate is as clear as possible and morally and legally speaking. So I just wanted to clarify because I don't want misunderstandings.
Hey, thanks for doing an interesting panel. I have 2 questions. First, you all discussed emerging mechanisms to govern private military contractors in war zones and how this is still a work in progress. So private military contracting seems to me to be sort of a boom and bust business, that there was a big boom in the first decade of the 21st century, and now it's kind of tapering off a little bit. So with that in mind, I was wondering how to maintain this momentum for regulation and rulemaking when there's a lull in the business itself. So that's the first question. The second question is just speculative. I was wondering whether you think there's any role for private military contractors in humanitarian disasters or humanitarian operations. That's all.
I'll take the first part on the momentum, and then I'll pass you for the second one. So with respect to the momentum in regulation and perhaps slowing down of the business, it's an interesting question that you're asking, and one that I've actually asked myself a couple times. I think there is still momentum for regulation. I mean, like I said, just 3 days ago, there was another proposal coming on the table for monitoring and enhancing oversight. And all industry players, states, corporations, civil society, all seem very keen on moving this forward. And when you think about what these initiatives have achieved or have the number of meetings, the number of brainstorming, the amount of brainstorming that has been put, and the effort that has been put into it in the past couple years, it's still ongoing, and so I haven't seen something slowing down. On the contrary, I think the fact that the UN is now joining the momentum in a way is only helping. So I agree that this is something that you could worry about or wonder about, but I haven't seen it in practice happening. Now, with respect to humanitarian operations.
Can I just add? I think there's an element here that is still a work in progress in terms of the regulation, and that is affecting the fiscal bottom line of the organizations. We know there are lawsuits ongoing for abuses committed by contract personnel. Now, you could criminally sanction the individual contract operatives, but that doesn't necessarily harm the corporate entity, right? It doesn't harm the corporate bottom line. Of course, it could maybe become a factor in whether or not they're going to be able to get a future contract. I mean, their record of how many of their employees have been criminally prosecuted it would seem to me, would be a valid consideration when you're making a contract bid. But how these lawsuits progress, I think, is going to be very significant. Because if contractors perceive that abuses of their employees will lead to large monetary damages, then obviously it's going to create a huge incentive to make sure that those employees are following the rules.
Just private contracting is already a very big deal in humanitarian activity. And one example is in UN operations, both peacekeeping operations and just in the maintenance of regular UN missions. In the peacekeeping and peace enforcing realm, for example, states are obligated, as part of their UN membership, to provide military personnel and police personnel to peacekeeping forces. That's what the peacekeeping and peace-maintaining forces are made up with. Now, if a country has no national police force, for example, the United States, then how are they going to fill that obligation? They're going to fill it by giving Dynacorps a contract. And then even where humanitarian action is private, say not the United Nations, but there are private nonprofit organizations that are doing humanitarian work. It's very much the same. There are analogies to the military's use of contractors for a bunch of support services, and then for even up to and including the delivery of the humanitarian service itself. It may be digging a well, it may be driving the truck that brings in the food. As often as not, it's security. So I think whether we're talking about the state as the humanitarian actor, say through the United Nations, or private entities, religious organizations, Médecins Sans Frontières, whatever, again, for better or worse, the use of private contracting in the humanitarian realm is already pretty well established.
Question over here.
Yes, thanks. I have a question regarding the draft international convention on the private military and security contractors. In terms, you mentioned, Mr. Rona, in your presentation that it would be work on filling the accountability gap that you've all been talking about. Is there mechanisms, since the treaty is going to be inherently state-based, that would hold the states accountable for the conduct of the private military and security contractors that they hire? Or are there other mechanisms for, I guess, quote-unquote, disciplining contractors who would misbehave under those circumstances?
The main focus of the convention as it presently is drafted is to require states that are parties to the convention, which of course inevitably is a voluntary process. States will or will not join up as they please, but if they are, then they will be obligated to legislate certain measures into their national legal system. Those measures will include accountability for contractors in ways that may not presently exist precisely because of the transnational nature of a lot of these contractors. Where do the big contractors come from? They come from Western states. They come from the U.S. and the U.K. Where do they conduct their operations? Not in the U.S., not in the U.K. And very often, the places where they do conduct their operations, obviously these are the places where they're going to be violating people's human rights if they do, don't have the mechanisms or don't have the will to prosecute them, or by virtue of bilateral arrangements, these people will have immunity. And yet, they may not be prosecutable in the state of origin because of the lack of a legal framework or a legal requirement or a jurisdictional ability of a prosecutor to bring a case against them. The convention would require states to enact legislation that fills these jurisdictional and impunity gaps. I think as presently drafted, that would be the single strongest way in which the convention addresses the point that you raised.
Is there a question over here?
Yes.
Sorry. Yes.
I'd like to direct a statement and get a response from the fellow that has the son in the. I have the utmost respect for you and your son. Him into the service of our nation. With all due respect, I direct this to you. I was in the Vietnam War. I served on a patrol boat And as far as people that are in private sector protection services, them being not as moral as people in the military, I tend to disagree, because I have seen devout Christians turn into hardened killers. I'm not kidding. I'm talking about the officers and enlisted men. And I don't. And you were alluding to those private people being not as moral as the people in the military. I would like your response. I disagree with that.
Well, first off, I think I emphasize that you know, we're dealing with presumptions here, right? The focus of my focus is on the relationship between the actor and responsible command. That word responsible is important. I was a prosecutor in the military for many years and a defense lawyer. I saw a lot of soldiers who were social deviants, right? In any society, you're going to have highly moral people, and you're going to have people who lack morality. There's no question about it. And it would be ludicrous for me to suggest that every private military contractor is somehow immoral, and every member of the military is this high, haloed moral person. There are exceptions in all organizations. But I think the role of the culture, right, the culture of a professional military matters. Okay, and what I would suggest to you, first off, I admire your service and what you did for your nation, and I regret that you had to.
I think your son is the hero.
I regret what you had to confront, right?
And but your son is protecting our nation. All we did was.
No, but the point is that the military institution itself has a mechanism that is supposed to function to correct those deviations from the norm. That is the assumption of the law of war, or the law of armed conflict, or international humanitarian law, whatever you want to call it. The doctrine of command responsibility is central to compliance with the law. Now, why is that? Because the people who created the law understood that when you put people in mortal combat, it's very difficult to preserve that sense of humanity, as you're pointing out, as James McDonough pointed out. Now, maybe that platoon leader was more devoted to that than the leaders that you had, and that's regrettable. But at least it's an institution.
I'm not trying to. They were good leaders.
But
they knew their job.
Yeah, institutionally, I just believe, and it's not just the American military. I think professional militaries understand that a core function of leadership is preserving that line, and I'm not sure if that same ethos of leadership is as inherent in the private sector as it is in the military.
I want to.
In the private sector, they were once military.
Exactly. That's actually, I wanted to follow up precisely with that point, that a lot of private security and military contractors are former military personnel, veterans that have decided to kind of continue serving their nations, also very often by way of working for a private security military company. Another point I wanted to make with respect to this ethical aspect is Professor Asa Kasher from Tel Aviv University, who drafted the IDF, the Israel Defense Forces Code of Ethics, has actually very much reflected about what he calls the interface between private security and military contractors and soldiers from the ethical standpoint, because that's his field, military ethics. And he has some very interesting writing about this, so if you're interested.
Unfortunately, we've run out of time today, but we just want to thank you so much for attending on the behalf of the Journal and the university. We do have a reception upstairs with hors d'oeuvres and beverages if you'd like to continue talking, and if we could all just thank our panelists as well one more time.